some breakthroughs happen in unlikely places. It was on the western frontier, not Boston or New York, that women first served on juries with men. The women battled overwhelming sexism, but still managed to fulfill their duty, bringing law and order to their crime-ridden towns. This advance occurred in the notoriously wild Wyoming Territory. And what happened in Wyoming reversed centuries of legal tradition. Juries have been used in the English legal system since at least the 12th century, but women were excluded from nearly all juries. The influential English jurist, Sir William Blackstone, summarized the common law view of female jurors when he wrote Commentaries on the Laws of England in the 1760s. Blackstone stated that women were not allowed to be jurors due to a defect of sex, propter defectum sexus, a term he did not further define. The only exception was an all-female jury called a jury of matrons. These juries served in cases that involved inspections of women's bodies, such as when a widow was suspected of feigning pregnancy in an inheritance case, or when female convicts pled their belly, claiming pregnancy to avoid the death penalty. The American colonies adopted the English common law system, including its general prohibition on female jurors. The jury of matrons continued to be used occasionally, most famously in the Salem witch trials. A jury of matrons would examine the defendant to see if she had a witch's teat or a devil's mark. The arguments of opponents to women's jury service mirrored the arguments used in the anti-suffrage movement. Women belonged in the domestic sphere and should confine themselves to duties around the home. If women were called to jury duty, they claimed, everything at home would fall apart. They said that women were not reasonable enough to evaluate facts and apply the law. Finally, they argued that women were too fragile to deal with what they would be exposed to in a courtroom.
Criminal court trials often involve testimony of the foulest kind, and they sometimes require consideration of indecent conduct, the use of filthy and loathsome words, references to intimate sex relationships, and other elements that would prove humiliating, embarrassing, and degrading to a lady.
When jury service for women finally occurred, the American West led the way. This was partly because women's suffrage happened first in the West. Suffrage often preceded jury service because jurors were drawn from eligible voters. The Wyoming Territory was the first to give women the right to vote and to serve on juries. Wyoming became a territory in 1868. The former hell-on-wheels towns had settlers moving in, but all was not quiet on the frontier. In May, a group of gunmen took over Laramie City for several months. They terrorized residents, forced ranchers to sign over their property, and murdered people in their saloon, known to locals as the Bucket of Blood. In the end, the townspeople banded together and fought back. In October, vigilantes hung some of the criminals who had terrorized Laramie. Others left town. This brought a temporary respite, but was not enough to end the lawlessness for good. This was the state of affairs when a year later, the territorial legislature passed a law giving women the right to vote. It was signed by Governor Campbell on December 10, 1869. In March 1870, John Howe, Chief Justice of the Wyoming Territorial Supreme Court, ruled that the Suffrage Act allowed women to serve on juries. As Associate Justice John Kingman recalled,
"We had a long consultation and came to the conclusion that since the law had clearly given all the rights of electors to the women of the territory, they must be protected in the exercise of these rights."
Another motivation for the justices was the out-of-control crime in the territory and their belief that women might be the ones to do something about it. The previous all-male juries were called a perfect farce by one Wyoming newspaper.
How about a verdict?
Can't you see we're still considering the evidence?
Deliberation time was spent in gambling and card playing, and in trying to bribe the attendant officer to go and bring in a bottle of whiskey.
When women jurors arrived, both the atmosphere of the jury room and the rate of convictions changed. The first mixed jury was a grand jury seated on March 7, 1870, in Laramie. 6 men and 6 women convened in a store. The women included Eliza Stewart, Laramie's first schoolteacher; Amelia Hatcher, the owner of a millinery shop; and Sarah Pease, the wife of an attorney. Pease was the only juror to write a detailed account of her jury experience. She said the court wanted women because male jurors didn't pay attention and would not convict defendants they knew. It appears Sarah Pease had discovered a male defect of sex. Justice Howe presided over the cases in Laramie as part of his duties as a Supreme Court justice. Justice Kingman sat in as an observer. The jury heard cases ranging from cattle theft to murder. Sarah Pease wrote that some people believed the defendants had nothing to fear, for women were chicken-hearted, and their tender feelings could easily be wrought upon. This did not turn out to be the case. In their first murder trial, the female jurors voted for more serious charges than the male jurors. 3 men voted to acquit. No women did. After 3 or 4 criminal trials, defense lawyers started to use their peremptory challenges to get rid of female jurors. But as Justice Kingman recalled,
the court checkmated this move by directing the sheriff to summon other women in their places instead of men.
some folks started to get nervous. Justice Howe.
After the grand jury'd been in session 2 days, the dance house keepers, gamblers, and demi-monde fled out of the city in dismay to escape the indictment of the women grand jurors.
A jury with women was the first to enforce the law requiring saloons to be closed on Sunday. This drove saloon owners and the rougher elements in town slightly crazy.
This is an outrage!
But Justice Howe was pleased with the results of the female juror experiment. When their service ended, he complimented the first mixed grand jury.
If future grand juries in this country shall follow the example you have set, assurance will thereby be given to all that crime and immorality will no longer be winked at, but all offenders will be brought to justice.
News of the female jurors was telegraphed out from Laramie. There was tremendous excitement, as this was the first true jury service by women. The news appeared in publications across the country and in Europe. King Wilhelm I of Prussia sent a cable to President Grant congratulating him on this advancement for women. Though applauded by some, the female jurors still faced hostility. A widely disseminated rhyme criticized the jurors for leaving their children.
Baby, baby, don't get in a fury. Your mama's gone to sit on the jury.
The Cheyenne Daily Leader suggested female jurors would dissolve into wrecks when they were sequestered for a few days for a trial.
It will be almost a miracle if some of the delicate women going through this painful ordeal do not sink under the weight of their privations and return to their homes with shattered nerves and ruined health.
In reality, one sequestered juror said she would have stayed for months to make sure the guilty party didn't slip away. Although the female jurors impressed many, they did not last long on Wyoming juries. They served for 3 court terms in Laramie and Cheyenne from 1870 to 1871. Justice Howe left Wyoming due to health problems in the fall of 1871. Howe was replaced as Chief Justice by Joseph Fisher. Fisher did not follow Howe's ruling allowing women jurors. Some have speculated that Fisher found a conflict with another Wyoming statute. A law that limited jury service to men was enacted 3 days before the December 10th Women's Suffrage Act. But other forces were at work here as well. There was never overwhelming popular support for female jury service. The belief that the jury was not a place for women persisted among many. and certain interests in town were not happy with the woman juror experiment. They wanted juries that would, as Justice Howe would say, wink at crime. Local lawyers were overheard saying,
"We can't clear a client if he's guilty before a woman jury."
the women were so good at their job, they got rid of them. When juror Sarah Pease wrote about her jury service years later, she suggested that women had been removed because they followed the law. Although women's suffrage continued unabated in Wyoming after 1869, women did not sit on juries again until 1950. The fight for jury service would continue to be fought on a state-by-state basis in the U.S. for years to come. But what was once a subject of humor for newspapers slowly became a reality. And that breakthrough on the frontier was never forgotten.